too, so we can
introduction
get
of you?
started
And then I'll
again.
just say something quick about me. And
I'm delighted to introduce John McKay and Eric Miller, who agreed to be here for the panel on what I have titled Representative Processes, so to talk about the class action cases and the voting cases. So Eric clerked for Judge Silverman and for Justice Thomas. He's co-chair of the appellate practice group at Perkins Coie now. In between those two jobs, he did a number of things in DC, which he may talk about. He was at the SG's office, the FCC, and the Civil Appellate Division of DOJ. John McKay is now teaching constitutional law here at SU. Before that, he was the U.S. Attorney for the Western District of Washington, also a former White House Fellow, and who has also done various things in D.C. Most recently, he led the U.S. State Department Rule of Law project in Ramallah, Palestine, advising prosecution, police, and security services, and, as I said, teaching constitutional and national security law. So thank you both so much for being here today.
Well, thank you very much. And I want to welcome those who have joined us online for this panel for our portion of the upcoming Supreme Court term. We're going to split this along two lines. We've each got two cases that we want to present. Then we'd like to talk a little bit about the upcoming term in general, and then we're just going to gossip about the court a little bit at the end, and hopefully anyone with questions or comments in a similar vein are welcome to participate in that as well. It is going to be, I think, a very interesting term, as those of you who've been here all day have already learned, and there are some very interesting issues to come before the court. So it's fun to have this opportunity, and it's an honor for me to be here with Eric Miller, who obviously has a stellar background in constitutional law. I often tell people I'm sort of a fake constitutional law professor up until now when I'm teaching it. And I've had the privilege of arguing on behalf of the United States at the circuit court level, and not nearly as prestigious as Eric's work there. So it's an honor for me to be here with him. I hope that we can shed some light on a couple of interesting areas. One in the area of class actions that Eric's going to address, and I'm going to speak on voting rights, two voting rights cases that are coming before the court in this term. We're going to alternate between them. Hopefully that won't be too confusing, but that way you don't have to listen to either one of us talk for too long at any one time. And I think when we've presented the basic cases, we'll be happy to entertain questions, but our group isn't so large that if someone had a burning question, we'd be happy to entertain it. And we'll repeat the questions from up here so that our online audience can also participate and know what the question is, and the same with your participation in any questions that you have. So I'm going to present two cases. One is Harris versus Arizona Independent Redistricting Commission, and the other is Evenwall versus Abbott, a case out of Texas. And they both present slightly different but interesting cases, interesting issues before the court. The first is the one that I'm going to talk about in my first section, then I'll turn it over to Eric to report on one of his. This is the Harris versus Arizona Independent Redistricting Commission. Ironically, this will soon be the second decision on this exact same issue, which is exact same subject, which is the Arizona Independent Redistricting Commission. The court handed down an opinion one day before it accepted review of this case, and the first opinion relating to the Arizona Independent Redistricting Commission was whether or not the process Arizona adopted in creating an independent districting commission would survive constitutional scrutiny, and the court held that it did. Essentially what Arizona has done, and this may surprise some of us, it attempted to establish and did establish a redistricting commission, which is essentially bipartisan. And so the bipartisan commission was charged with the normal process of creating appropriate legislative districts under state law. And now the methodology used by the commission is going to be before the court in the coming term. So there are a couple of issues present. They go to the question of one person, one vote, and at least in the first instance. And in the second instance, It's kind of an interesting catch that the state of Arizona finds itself in, and it kind of goes like this. You may be aware of the fact that the Supreme Court in the case of Shelby County has ruled that Section 5 of the Voting Rights Act is essentially now a rudderless ship. We must have one person, one vote, but the pre-clearance procedure required by the Department of Justice under the Voting Rights Act for states which have historically discriminated in the voting rights process, while it still exists, there is no formula by which the Justice Department can determine which jurisdictions must have retroactive correction of its prior voting right discrimination. So while the law still exists that certain jurisdictions would be subject to pre-clearance procedures, there are no procedures because the court struck down those procedures as unconstitutional in the Shelby County case. Now along comes Arizona. Arizona has, in good faith, they've stood up this independent commission, and the commission, at the time it was stood up, goes about the business of, in a nonpartisan way, creating, of course, all of these things are nonpartisan and there's no politics involved, but Arizona goes about the process of creating these new districts, but using the assumption that the same sort of formula would exist and be applied in Arizona, and that therefore they wanted to get ahead of the what would be the pre-clearance requirements under the Voting Rights Act, and by their own admission now in the case pending before the court, weighted more heavily some districts than others in order to, in essence, correct past voting rights discrimination. After having done that, the Shelby County case comes down and says, but there are no longer any formulas for you to rely on. Not to put this in purely political terms, because we're talking about the United States Supreme Court where we know there is no politics. Many groups now are weighing in. I think the conservatives saw their opportunity here to pounce on the work of the commission and to argue now that any deviation from what would be argued as one person, one vote, even if it was in good faith compliance with the test that existed at the time, violates the Voting Rights Act and violates equal protection, more specifically equal protection, that more weight is given to certain districts than others, and there is no justification for that. So those are the issues that will be before the court with respect to the Voting Rights Act in this case, and it will be, I think, very interesting to take a look at how the court approaches it. I'm going to spend a little bit more time discussing the cases together and maybe what the significance could be of this case and the case out of Texas, the Evanwell case that I'm going to talk about in a moment, and where the court may be going in terms of guidance to the lower courts on how to handle such challenges under the Voting Rights Act, and whether standards might be created for states that are attempting to answer the question of what does one person, one vote really mean? And we thought this was something that was established in the 1960s, but it's back, and it's back in a pretty big way, in particular in the Texas case that I'm going to speak about in just a moment.
All right. Well, thanks, John. It's a pleasure to be here with you and all of you. I'm supposed to talk about the class action part of the court docket that's coming up. And before I do that, just a brief look back at class action cases from last year. There was only one, but it was kind of an interesting one. This was Dart Cherokee Basin Operating Company against Owens. This was a case under the Class Action Fairness Act, which was a statute passed a few years ago to make it easier to get class actions out of state court and into federal court. And under CAFA, as it's known, you can remove a case to federal court as long as there are more than 100 members in the class. You have minimal diversity, so you just need one plaintiff and one defendant from different states. And that was one of the big requirements that the requirement of absolute diversity under 1332 is what made it very difficult to remove a lot of class actions before CAFA was passed. You need minimal diversity, and you need the amount in controversy to be more than $5 million. The other change that CAFA made was that while a decision of a district court to remand a removed case back to state court is ordinarily not reviewable on appeal, CAFA provided that a discretionary appeal in the discretion of the Court of Appeals on a very expedited time schedule to review a remand decision under CAFA. So Dark Cherokee was a class action by holders of oil and gas leases alleging that they had been underpaid. The defendant filed a removal notice, said, you know, all the requirements are satisfied, the amount in controversy is more than $5 million. In the district court, plaintiffs questioned whether the jurisdictional amount was really satisfied, and so defendants put in a declaration from somebody at the company that said, you know, on plaintiff's theory of the case, the damages would be $11 million. The district court then said, you know, that's too late. You should have put in your removal notice evidence to show that the amount in controversy requirement was satisfied, so I'm dismissing. The defendants sought to appeal to the 10th Circuit. The 10th Circuit denied permission to appeal and then split evenly en banc when rehearing was sought, with the competing groups of judges discussing the question of whether or not a bare allegation in the removal notice is sufficient or whether you need to put in evidence. The Supreme Court reversed in a 5-4 decision, written by Justice Ginsburg. Nobody, and what she said was, you know, removal under this statute is just like, you know, the jurisdictional allegation under 1332. You just need to allege that the amount in controversy requirement is satisfied, and if that appears in the complaint, you know, that's good enough. Nobody really argued about that at the court. The interesting question was that there was a 4-justice dissent, Justice Scalia writing for himself, Justice Kennedy, Justice Kagan, and Justice Thomas. And what he said was, we shouldn't even be reviewing this question because all that the 10th Circuit did was deny a discretionary appeal. And you know, you may think that they did it because they had a view about how, you know, what has to be alleged in the complaint. And indeed, Justice Ginsburg devoted a large portion of the majority opinion to arguing that, you know, that must have been what they were thinking. But we don't really know that. And they might have done it because, you know, any number of other discretionary considerations. They thought this wasn't, you know, the best vehicle for doing it. They thought that it would be hard to decide the case within 60 days that the statute imposes on them. You know, so who knows? Like, all we can do is, you know, ask, did they abuse their discretion in denying this discretionary appeal? And we can't say that they did. Justice Thomas, writing separately in dissent, went even further and said, you know, our certiorari jurisdiction from the courts of appeals is limited to cases in the courts of appeal, and a petition to hear a discretionary appeal is not a case in the sense of the statute. So, you know, it doesn't matter what they had said. This is just not something that's reviewable. And this is a position that has come up before in the habeas context. Under the federal habeas statute, generally you need to get a certificate of appealability from the district court or the Court of Appeals to appeal the denial of a state habeas case to the Court of Appeals. And the Supreme Court held in Hone, over a dissent joined by Justice Thomas and others, that the denial of a certificate of appealability is reviewable on certiorari, and so he was adhering to his view that that's not really a case either, and neither is this. So, an interesting question of certiorari jurisdiction, a fairly obvious question of, you know, how to plead the amount in controversy, and one that, as several of the justices acknowledged, it's not going to make that much of a practical difference because, you know, had the rule been the other way, you know, it's not that hard to. Usually, in most cases, it's not that hard to show that the amount is going to be $5 million. Turning to the cases this term, one that I think you heard about this morning that is a class action case, so I will mention it just for the sake of completeness, is DirecTV against Imburgia. That's a case about class arbitration and whether, you know, how to construe a contract that has a non-severability clause to take account of the possibility that a state might say that you have to allow class arbitration. which we now know under AT&T Mobility against Concepcion, a state can't require the availability of class-wide arbitration. And if you have an arbitration agreement that doesn't allow for class-wide arbitration, that's still going to be enforceable. So of the two cases that we're going to talk about here, the first one, which is going to be argued just next week, is Campbell-Ewald against Gomez. And the issue here is whether an offer by the defendant to settle the lawsuit for everything that the plaintiff has asked for, so just a capitulation by the defendant, whether that moots a case. And if that sounds a little bit familiar, that's because the same issue, sort of, was before the court 2 years ago in a case called Genesis Healthcare against Simzik. And Genesis was a collective action under the Fair Labor Standards Act, which has its own statutory group action provisions, but for our purposes, basically just like a class action under Rule 23. In that case, the defendant made an offer to the named individual plaintiff, said, I'll give you everything you're entitled to if you were to win. It was not accepted. The case went forward. On appeal, the Third Circuit said, we think that the individual plaintiff's claim was mooted by that offer. And the plaintiff conceded that in the Court of Appeals. Notwithstanding that, we think it's okay for this case to go forward as a class, because even though the individual claim is moot, the class claims aren't moot. The defendant sought cert. Plaintiff did not cross-petition on the question of the mootness of his individual claim. The Supreme Court, in an opinion by Justice Thomas, it was 5-4 along the common ideological lines, said class action is moot because the individual plaintiff's claim is moot. And if there isn't an individual plaintiff with a live claim, you can't have this go forward as a class. And he said, we're not deciding that the individual claim was mooted by this offer that was never accepted, but we're going to assume that, because that's what the Court of Appeals assumed, that's what the plaintiff conceded below. If the plaintiff wanted to challenge that aspect of the Court of Appeals judgment, he could have cross-petitioned. He didn't. So we're just assuming that without deciding. Justice Kagan wrote a dissenting opinion that said, if that's a ridiculous assumption, an unaccepted offer does not moot the case. And even though it wasn't argued below, we shouldn't be deciding the case on this assumption that is, in her view, really far-fetched. This is never going to come up again. This question of whether the unaccepted offer to the plaintiff moots the whole class won't come up again, because in fact it doesn't moot the individual's claim. And so you can, and she said to the reader, feel free to relegate the majority's decision to the furthest reaches of your mind. We've all failed to heed that admonition, because here we are 2 years later still talking about it. And it has come up again, in this case, Campbell-Ewald, which involved, of all things, a Navy recruiting campaign. The Navy wanted to recruit more sailors, so they hired a company that decided to go about this by sending text messages unsolicited to lots of people's phones saying, join the Navy. And there is a federal statute, the Telephone Consumer Protection Act, that restricts sending unsolicited faxes and apparently text messages and the like. So Gomez sued, and the defendant said, fine, you got us. Here is your $1,500 statutory damages plus $3 in interest, which is all that you could get if you won. And we will stipulate to an injunction that says we can never do this again. So goodbye. Gomez apparently thought that this was an offer he could refuse. He did not accept it and sought to go forward as a class action. And the Ninth Circuit said, you haven't accepted the offer, your case isn't moot, you can go forward. There are two issues in the court. The mootness one that we've just been talking about. The other issue in the petition is a question of sovereign immunity or derivative sovereign immunity, because they were, after all, a government contractor as part of a Navy recruiting campaign. That I won't say more about. But just focusing on the class action mootness question, the defendant's argument is basically the job of the court is to decide actual controversies between litigants who disagree about something. And we don't disagree about anything because we've already said, you win, here's your money. We've given you everything that you could possibly get. You have no interest of your own in prosecuting this case anymore. And they cite a number of 19th century cases where the defendant tendered payment that was allegedly due to the plaintiff, and the court said, well, there's no longer jurisdiction to review this anymore. The plaintiff's argument is Rule 68B says, which is the rule that governs offers of judgment, says an unaccepted offer is considered withdrawn. I didn't accept the offer, that's the end of it. You can't make me go away by offering something when there wasn't acceptance of it. And then they point out there are the various contexts in which courts can continue to do things in a case even after the parties have agreed. For example, the entry of a consent decree, the court can effectuate the agreement of the parties. The United States is supporting the plaintiff on both issues. This is of considerable practical significance to class actions because, particularly for these things like the TCPA, where you have large numbers of plaintiffs, but
I'm going to move this just a little closer to you.
Okay. Large numbers of plaintiffs, but relatively modest damages for each plaintiff. It would make it much more difficult to successfully litigate a class action if, every time you filed one, the defendant could just give the named plaintiff his money, and that would be the end of it. So, as I said, that's up for argument next week.
Okay, thank you, Eric. So we're going to veer back to voting rights for a moment, and I'm going to start by moving in the Arizona scheme before discussing the Texas case, which is the second case I'm going to present. Arizona, Texas, two shining examples of redistricting success politically in the country on display in the Supreme Court, he said with some sarcasm. In Arizona, the allegation is that this nonpartisan commission that was established in an effort to meet the pre-clearance requirements that they thought would be in existence for the Justice Department, have now, in violation of the 14th Amendment, packed certain districts with non-white voters, non-Hispanic white voters, so basically pushing the white voters into larger districts and leaving smaller districts that would be principally Hispanic. And the allegation is that you are, on the one hand, diluting the voters of white persons, and on the other hand, overweighting the voting rights of Hispanics. So this is the allegation now that is so the factual allegation that supports the argument in Arizona. In Texas, the issue is different. In Texas, more clearly presented is the question, once again, which we thought was resolved, whether or not one person, one vote is going to be based on population or voters. And that is what will be, once again, before the court. We thought this was resolved in the 1960s in two cases that the court made the decision and let stand a scheme under the Hawaiian redistricting provisions, which allowed the districts to be created essentially along population lines, but which used some predicted voting statistics in order to assure the correctness of these districts from a one person, one vote standpoint. In Texas, the argument is a little bit different. It's sort of inverted, because in Texas the allegation is that if one person, one vote applies, then it is most correctly applied when looking at eligible voters. This is what is known as Citizens Voting Age Population Analysis, or something called CVAP, CVAP. It is used by many states to, as I said, assess the correctness of redistricting in terms of population, and the check on voters occurs through CVAP. Now, I think it's fair to say that those who think that the voting rights of, as one commentator put it, rich white males are being diluted are arguing that the correct constitutional standard should be voters. So you can see the political lines taking shape here. In fact, I think there are something like 50 amicus briefs filed in the Supreme Court on this case, lining up from the ACLU to every political group that you can imagine filing briefs in this case. Some are shocked that the case was accepted at all for review, because there isn't a split in the circuits here on how this is being handled. This is a case that's coming up from Texas, and the court seems to be willing to entertain the question of what it means to say one person, one vote again. So it's raising a lot of concerns. Maybe I'm going to suggest maybe not quite as justified as some of the commentary has gotten a little bit hysterical over what the court is up to by accepting review of the one person, one vote standard that has been seemingly familiar to a lot of us. So essentially, just to kind of state the way this frames out in Texas, if you take raw voter population in Texas, the population variance between districts averages something slightly less than 10%. But if you take citizen voting age population, this is CVAP, and compare them between districts, the variance sometimes runs as high as 50%. So if you're going to attack redistricting from the standpoint of those who think that it should be voters and who would be overly concerned about counting population of individuals who may not be eligible to vote, and I think it's pretty clear that they're talking about large areas with Hispanic population that are not eligible to vote because they're not documented, or for whatever other reason, then you are going to be diluting the votes of white individuals, non-Hispanic whites. So the challenge is to the really kind of a basic consideration in our Constitution, which is what does it mean when in a 14th Amendment equal protection analysis, we say one person, one vote? Is it going to be based on population, as has been the general understanding, or are we going to drill it down to be eligible voters, and that constitutes the standard? And from that, we would pivot to questions of just whose rights are being diluted here. So you can see the stakes can be high if some of the commentators are right that this is the court's opportunity to come in and give direction to the states, because I think it's fair to say that following the two decisions in the 60s, the Symington case and the Burns case, I think I've got that right, that these two cases, it's the Symington, the Reynolds case and Burns versus Richardson, states are left to create their own standards, and most have left them looking somewhat like the decision in Burns, which is to base most redistricting on population with a check on voters. But if the court were to announce a new standard, and that standard would be eligible voters, you'd see pretty dramatic restructuring of what's going to happen. So there's three potential outcomes if you look at it in this way. One is we'll stay with population, and in fact the court might say, look, it is population, and sort of remove the status quo ambiguity that's been in place for 40 years. The court could say we're going to change completely, and we're going to base this on eligible voters. This CVAP standard would become the core of what one person, one vote is. Or the court could say, here are guidelines for states themselves to make these decisions to determine what it means. I think that's the most likely outcome, that the court's going to reiterate that states are going to have to answer this question themselves about what it means, and they'll find a way to probably avoid having to push the voting requirement down the throats of all of the states. And I'm not sure how the court will do this or what they're going to say, but I think that's what we're going to see, that the court will essentially attempt to modify the status quo by including language that would stress the importance of eligible voters to this process without requiring it. And I think that's a real possibility. The court wants an opportunity to weigh in on this question of what one person, one vote means. But we're really getting at what one would suggest would be a very political process, a determination that people might make rather than 9 justices, or at least legislatures might make rather than 9 justices. And so it'll be interesting to see whether they, without a split in the circuits, are willing to change kind of a major tenet in American politics. But the stakes are very high, in particular in districts where you have arguably overweighted population to eligible voters. And so the numbers in Texas, you can see that those might be replayed across the Southwest, for example, where states have made a good faith effort to try to comply with what the United States through the Department of Justice has required to make sure that there are not overtly discriminatory voting schemes attempting to gerrymander around population and changes in population, and now to have the Supreme Court weigh in as the standard bearer. So in a way, some of these are related to the statistical questions that I think Eric's going to talk about in his next question in class actions, which is, will we be turning the question of voting rights from what is generally accepted as a more reliable standard, that is, the census data on what the population is tends to be more reliable than who the eligible voters are. It's a much more difficult thing to establish, absent maybe a much more restrictive state scheme that would attempt to document voters in certain ways that the court has frowned upon in the past, and which would be very controversial to try to establish a state scheme that would increase the reliability of a statistical understanding of what the voting population is versus the raw population, if you will, that we test in census data. But it is I think fair to say that most commentators looking at this would agree that the population data, for whatever reason, at this point in time, is much more accurate than the analysis of registered voters. Of course, to those who now see the opportunity to attack legislative schemes that are attempting to meet guidelines that were part of the analysis before the Shelby County case, this may be the clue that the court may have sort of opened the season on questioning how we look at voting rights in the United States. So this case, the Evanwell case in Texas, has the potential to turn into, I think, a bombshell case in the coming term. So we'll see if that's true, if the court takes the middle road that I'm suggesting. But if it were to announce a new rule that was pinned to the question of voters rather than population as the core determination of one person, one vote, we're going to see some fireworks.
All right, thanks. And just one thought on that case. I mean, in terms of why they took it, this is an issue that's been around for a while. And Justice Thomas, back in 2001, a case called Chen, wrote a dissent from the denial of cert, flagging this issue and saying, we should take it. So he at least has been suggesting that the court should resolve it for a while. And as you say, this is the variation in this case between voting age population and total number of people is pretty big. So the difference is presented more starkly.
Yeah, and I have to say you're absolutely right. I meant to mention the case because I think it was, even though now, 14 years ago, exactly the issue now that's before the court. So he certainly outlined the issue for us a number of years ago, and it will be before the court, and we'll see what they do in the next term.
It's also interesting. One point you made about there are sort of two different issues before the court in the sense of may the state consider voting age population or citizen voting age population or total number of people, and must it? And the plaintiffs here are challenging Texas's scheme, and Texas, in its brief, has argued, we could do either, and our choice of total population should be respected. The United States, which is supporting Texas on the second part of that, but not the first, and the federal government's position is no, you had to do total population. So there are sort of two different ways that they could go in answering those two different questions. But you had a question?
I guess my question would just be, was the concern that if you did registered voters, that's an undercount, and you could always register more people, right? So it isn't a good reflection. So this other one, CVAP, assumes everyone who could register, not who does, but who could, and that somehow would make it at least more accurate with respect to who's a citizen or not. And you kind of count everybody who could be registered as a citizen versus, I mean, is that part of the
We're supposed to repeat the question.
Yeah.
Okay.
Yeah.
So sorry.
No, that's okay. So the question goes to whether or not under the registering of voters, you would be deemed, whether the assumption of CVAP would be that you would register everyone who was eligible to vote. I think that is part of the assumption, and it goes to the basic debate that's likely to be before the court, and many of the commentators in the additional briefs, the Friends of the Court brief, are saying, which is, well, what does the Constitution mean? I mean, does it mean that we are talking, does it put a burden, for example, on people, citizens, who are eligible to vote, to register to vote in order for us to determine whether they're going to be represented? Or does the Constitution mean that we're going to represent the population, persons? And there's an interesting debate, where in the Constitution would it be persons versus voters? Which one, we're trying to, as I like to tell my students, figure out what they meant in that sweaty room in Philadelphia. And it may go to that kind of basic question of who is being represented and what does that mean when we say one person, one vote. So I think all of us know that when you talk about registered voters, there is much room for mischief in and among the states for how that takes place, what the motives are by the states in order to adopt registration rules. And I think maybe what we've been doing over a number of decades is relying on the idea that population would roughly fix those issues, and that population, we don't have to answer the question, is every person, whether they are a citizen or not, entitled to some representation? And historically, there are states that gave voting rights to non-citizens. And that is not a crazy issue within the United States of America. So to revisit this question and who gets to make the decision is kind of fascinating. I think that will be possibly before the term unless they punt and don't really address it. So yeah, I think that's a big question. I think the CVAP, the voting, the registered voters, is being held forward as this is the most correct way to determine what one person, one vote means. And I think those that are familiar with what states are capable of are a little bit skeptical of that.
Okay, so
I think it's
back on class actions.
Yeah,
okay.
class actions.
So the second class action case this term so far, and I guess probably somebody has pointed this out already in the earlier sessions, but the court has only granted cases to fill roughly half the docket. So there could well be there are more cases out there, and that'll be granted, and often big ones end up being in the second half of the year. So we're just talking about the ones that we know about at this point. But the second class action case that we know of is Tyson Foods against Buafakeo, which will be argued in November. And this is a case under the Fair Labor Standards Act. and it involves donning and doffing time. So, the FLSA imposes minimum wage requirements, overtime if you work more than 40 hours a week. And so working out whether somebody's been paid minimum wage and whether they've gotten overtime requires calculating exactly how long they worked, which raises questions about when you start the clock and when you end the clock. And there's a lot of litigation about this in the 30s and 40s, and a number of statutes, the Portal to Portal Act passed to clarify that. And this is all sort of sounding a little bit familiar, though there have been a couple of cases in each of the last 2 years. Under this last year in Integrity Staffing Solutions against Rusk, or Busk rather, the court considered warehouses operated by an Amazon.com contractor, where the employees had to submit security checks at the end of the day to make sure they weren't walking out with a jacket full of Kindles. And the question was whether that time counted as part of the workday, and the court said no. And just as an aside, one funny aspect of Portal to Portal Act, I think it's actually in the statute, is that there is a distinction between, or a statutory description of the work time and activities preliminary and post-preliminary to working, which is the only context in which I've ever heard anyone actually try to use the word post-preliminary. But the year before that was Sandifer against U.S. Steel, which involved various kinds of protective gear that the employees had to don and doff. And normally you get donning and doffing time as part of the workday, but you don't get time for changing clothes. And the court in Sandifer said, well, the gear that they're putting on is really clothes, and so they're changing their clothes, and that's not part of the work time. So this case involves a Iowa pork processing plant, and the employees have to put on such gear as hard hats, hairnets, smocks, knives, scabbards, and belly guards. I don't know exactly how the belly guard works, but Tyson gave its employees a certain amount of time each day.
I have a feeling that working with knives, you would want a belly guard.
Well, I suppose you, yes.
Yeah, it might be a good idea.
They gave everybody, depending on your position, 4 to 8 minutes a day for the time. Plaintiff said, well, it actually takes us longer than that, so we went overtime. The district court certified a class, and there was a trial, and the evidence that the plaintiffs presented consisted of an expert who did a sample of a bunch of employees and figured out how long it took them to don and doff their clothes, and then used a computer to figure out, well, how much overtime does that work out to for the employees on average. And the defendants pointed out, you're doing this sort of sample and this computation, but there are actually a lot of differences among these employees because you've got different people doing different jobs. They have different equipment depending on which job they're doing. They don and doff their equipment in a different order and in different places. And they also, importantly for overtime purposes, they work different amounts of time. So some of them, even with this extra donning and doffing time, are still under 40 hours a week and therefore wouldn't get any overtime. But the district court nevertheless let this go ahead as a class action. There was a trial, plaintiffs won, Eighth Circuit affirmed, and the defendants have now sought cert, which has been granted. There have been a couple of cases in the last few years in which the court has sort of frowned upon the idea of a trial by formula. Comcast against Barron's a couple of years ago, and then back in 2011, I think it was, Walmart against Dukes. And one of the key holdings of Walmart is that what matters for Rule 23's commonality requirement, because of course the key requirement for a class action is that you have common questions of law and fact. What matters is not so much that you have common questions, because for any group of plaintiffs, you can imagine common questions. What matters is the ability of a class proceeding to generate common answers to those questions. And if the answers are going to be different for the different plaintiffs, that's a problem under Walmart. So the defendant's argument here is essentially, this is just a trial by formula that you can't do under Walmart. We have a due process right to present individualized defenses to the individual claims of these individual plaintiffs. And so, for the people who, for example, didn't work 40 hours a week, we should be able to present that individual information about them and not face any liability to those people. And Article 3 says that you have to have an injury in fact in order to have standing, and somebody who hasn't suffered any injury in violation of the statute doesn't have standing, and they can't be lumped in to this case and recover. The plaintiffs say, well, no, actually there are a lot of common issues about all of these people, and those common issues predominate. And then they also sort of rely heavily on sort of an FLSA specific argument, which is under a decision from the 40s, Mount Clemens. The evidentiary standard in an FLSA case is that if the employer didn't keep adequate records of how long you worked, you get to prove your approximate time worked as a matter of just and reasonable inference. So their argument is, in this context, when we don't know how long it really took and the employer didn't keep those records, this sort of statistical evidence is good enough to allow us to recover, and therefore, since the individuals can prove their case that way, that's good enough for a class action. The United States is supporting plaintiff's position and focusing on that Mount Clemens argument. So it may be that this case will be more of an FLSA case than it is a class action case. Should it end up going that way, I think it is safe to say that we will see another case in the next few years about this sort of statistical approach to class actions, because it's an issue that's getting litigated a lot, and the court is likely to revisit it soon if it can't fully answer the question here.
Maybe I can just follow up with a question based on what you just mentioned, and that is to maybe look more broadly at the question of class actions. Some of us here have had experience in the legal services context where we look at the benefits of just the basic benefits of class actions, and a sense that the court is moving to or trending in the area of restricting class action lawsuits. Do you have any thoughts on the trends and how that might go beyond, say, the FLSA type of impact?
Well, I think it's fair to say that there is Walmart and Comcast, I think both were sort of strong statements for the principle that you really need. Walmart, just for some background, was a employment discrimination case by female employees at Walmart who said that they were subject to discrimination in promotion decisions, and the class was, I believe, the nationwide class of everybody who worked at the company, and the court said you've got thousands of different managers making sort of individual decisions. You're not challenging. It's not like there was some systematic company-wide policy that disadvantaged women. You just have just individual managers making decisions, and so there's no way to answer the question. Was plaintiff X a victim of discrimination by just looking at company-wide. You would have to look at the individual characteristics of that plaintiff and the person who made the hiring decision and so forth. So I think it is fair to say that there has been a trend toward insisting on finding genuine commonality in the class to allow the case to go forward, and I think we may see that continue. Now, I mean, those were Comcast was 5-4, so I mean, who knows how much farther they will go, but.
Well, before we open to questions and then maybe we talk a little bit about, I'm interested to hear what your thoughts are on what the term might look like and the way the future of the court. I mean, we have some changes coming in all likelihood in the future of the court. We don't know when that will be, but we can talk about that in just a moment. I wanted to go back just to the voting rights question, and you mentioned the Clarence Thomas. Justice Thomas decision on voting rights, and it's the Chen case. Is that right? It's 2001. But I think in that case, Justice Thomas, at least in his dissent, it was dissent from taking the case itself, from accepting review. But the choices that I was suggesting might be in play in the Texas case, which were population as a basis to determine one person, one vote versus voting eligibility to determine one person, one vote, or whether they would just, in one way or another, preserve the status quo and allow the states to make this determination. But I think in that case, Justice Thomas, the main core of his dissent was that we shouldn't leave the states to make these decisions. It either means something or it doesn't. We're going to need to choose something. So would you take that, if we're going to continue that analysis, would you take that as maybe an invitation to at least part of the court that they might look at mandating either one or the other?
That's why I would need to go back and look at exactly what he said. But I mean, I guess I will say that.
Let me just, I don't want to leave you at a disadvantage. I'm going to read you because I had marked this and meant to mention it. But what he wrote in that case was, the one person, one vote principle may in the end be of little consequence if we decide that each jurisdiction can choose its own measure of population, which is where we sort of left things after the Burns case and the Hawaii scheme on redistricting. It seemed to me that he was suggesting back then that maybe what the court's role here would be to announce what the Constitution means. I mean, it isn't a crazy thing to say that the Constitution and what it means is announced by the Supreme Court. Although I noticed that Rick Santorum in the presidential debates recently questioned that very thing, that really, why would the court be making decisions about what's constitutional and what isn't? Because the Constitution doesn't say that, and that maybe the president could do that.
Well, I mean, I really don't know in what context he said that.
You don't know.
It is, of course, the case that all three branches of the government take an oath to support the Constitution and have to interpret the Constitution in the course of discharging their sort of independently vested duties. So I would, but that's taking us afield from this question. To return to the issue of that you're raising. I mean, there is, of course, an argument that the Constitution does not commit a state to a particular theory of representative democracy, and there are sort of different ideas that one can have about what representation is and how representation ought to work, and a state can structure its own government accordingly. Those arguments were vigorously advanced by the losing side in the Baker against Carr and Reynolds and Sims case in the 60s. So having moved beyond that, that doesn't settle the question of does measure of population have to be something that the court can answer, but it does take, if you accept those cases, take some arguments against that position off of the table. So
it could be. That's exactly what they do. Yeah. It'll be very, very interesting. Okay, I think now would be a good time for us to open this to questions, although I wanted to save a little bit of time to talk about the court. So I would leave it to everyone here, whether they've got pressing questions or want to hear, I think, more from Eric Miller than from me, what he thinks of the coming term and what the future of the court may look like. Any preference? Why don't we just do that quickly, and then we'll have any range of questions on any of those topics, either the class action cases, the voting rights cases, or whether the Supreme Court of the United States. Would like you to go first, if you don't mind.
So what the future of the court?
Well, okay,
I'll tell you. I mean, for that you don't want somebody who studies the court. You want somebody who studies presidential elections. I mean,
well, let me put this in a context that for someone who was at the court might have a better perspective than I certainly would have. But I think it's fair to say that in this last term we may have seen more rancor than is the norm in some of the decisions, some of the opinions that came from the court would seem to me more personal than they had been in the past, and the trends of that, especially coming from Justice Scalia in terms of language. I think there's one. I think Scalia recently derided an opinion by Justice Kennedy as pretentious and egotistical, and I think it's the gay marriage case, pretentious and egotistical and egocentric, relating directly to the majority opinion written by Justice Kennedy. So it seems like a lot to me. That's one side of it, and then the other side that I think you may have some insight into is just the age of the court. You have, I think, by the end of this term, Justice Ginsburg will be 83. Scalia and Kennedy will be 80, and Breyer will be 78. So I think that leaves a lot of ground for speculation about succession and how the court might change. And I guess I wonder if you have any thoughts on that.
well, so there's two questions there.
Yeah, there are.
So the first question, I mean, you can read the dissenting opinions in Obergefell, the same-sex marriage case, and draw your own conclusions. I don't think that there are some, it's fair to describe that as a pretty vigorous dissenting opinion. Justice Scalia and plenty of other justices have written vigorous dissenting opinions in other cases in the past. It doesn't strike me as that different from what we've seen in some of the abortion cases and other sort of significant constitutional cases that provoke strong feelings on both sides. And despite what despite the sort of strong language that all of them sometimes use, I think that they are able to get past that, and they work together quite well. And they're all professionals, and they're able to have their differences in writing in their opinions, and they really don't personalize it. As to the fact that they are all getting older, as
Just like all
of us are, at the same rate. I remember, every 4 years, one sees sort of, in the next 4 years, N justices are going to retire. Where
Increasing the stage
N
of the
is
presidential
some
election.
number that is usually smaller than 9, but still unrealistically large. So all of which is to say that I don't really know who will retire over the course of the next 4 years. Who may have to leave, but I think it's likely that someone will, but there's really no way to speculate on that. I mean, I will say that despite their age, they are they're all pretty vigorous. When you see them in argument, they're active and engaged, and so I don't see any sign that anyone is slowing down. Looks like they're on their way out the door.
So on the ranker question, you would say no more than usual. We've seen this before. Not a big, okay, and that's fair enough. And I just want to ask you one other question before we open the floor, and that is maybe beginning with Obergefell, but also other cases, Justice Kennedy. Some commentators are saying Justice Kennedy tends, in the last term at least, to have trended more towards, if you can say there is a liberal side of the court, that he has sat on that side of 5-4 decisions more than on the conservative side. Is there anything about the upcoming term that you can think of that might give us some guidance on where Justice Kennedy might be? I don't know what that is, and I can't say that I have any guidance on any trend based on the coming term. But there is a point, I suppose, that they make that is Justice Kennedy tending more towards the liberal side than to the conservative side, and would this be something that would continue into the future in your judgment?
I think it's issue by issue, and so some terms, depending on the cases that you have, it looks like it's more one way than the other. But so I think it really just depends on.
And in the current structure of the court, it really continues to be Kennedy is the one that we're all watching the most closely
on
many issues.
On many cases.
Yeah. Okay.
Not all, but many. Yeah.
Right. Great. Thank you. Thank you very much. And we want to open this now. We've got about a little less than 10 minutes or 15 minutes to take some questions, and we're happy to also to hear comments. We'll do our best to repeat them for those who are online. Yes.
I read that some commentators suggest that the conservative wing of the court wants to strike the Voting Rights Act entirely. I don't quite understand how the Voting Rights Act interacts with these two cases that you've discussed. Do these two cases potentially give the conservative wing that opportunity?
So the question is whether the court itself has the Voting Rights Act in its sights as something that might just simply disappear. I think to go to the Arizona case might be a good example. The court, by striking down the formula that was used to review jurisdictions that had voting discrimination within its scheme, violations of equal protection, looking now at the state of Arizona, which arguably was acting in good faith to try to meet the formulas which now no longer exist, I think it's likely the court is going to say, no, you cannot use a formula based on a process that we struck down under a provision of the Voting Rights Act, and you may not take steps that would, facially dilute voters one way or the other, whether to correct past injustices or to meet your political aims. And I think the court may say that. So independent of whether the provision within the Voting Rights Act says so, now I think, in terms of just strict equal protection analysis, the court may simply be saying what's left of the Voting Rights Act in Section 5 just doesn't apply. I think that's a possibility in this case. I can't speak to the motivation of the court as to why they would do that, but it seems logical to me that the actions taken by Arizona, which would have been in furtherance of the voting rights section that they have found unconstitutional, will similarly be stricken.
And I would just add, when you say strike down the Voting Rights Act entirely, it's important to distinguish between two big sections of the Voting Rights Act that there's a lot of litigation under. Are Section 2, which is protects the right to vote and protects against schemes to deprive people of the right to vote, and has been applied in the vote dilution context, and a lot of the districting cases are brought under Section 2. And then there's the Section 5, and Section 2 covers the whole country. Section 5, which applied only to those states defined under the coverage formula that was invalidated in Shelby County and imposed a much more intrusive preclearance requirement. So Section 2 or Section 5 is out of the picture unless Congress enacts some new formula for defining its coverage. Section 2 is still there, and there are still cases being brought under it, and I don't see any sign that it's about to go away.
Any other questions? Anything from online or online listeners? Okay. Well, that being the case, I think we are done, and we'll take a break then until the next panel begins, which I think is the wrap-up panel, which will start at 3:15. So we've got about 10 minutes before the next panel starts, and we'll take a break. Thank you very much.